Hello, welcome to week one of Trial by Peers summer course. My name is Felicia Quinlan. I'm a Chief Deputy District Attorney with the District Attorney's Office here in Clark County.
I am Mike Saloom. I am a regular deputy district attorney at the district attorney's office. Felicia and I have been buddies for a while, so we're going to probably laugh a little bit during these, and you guys probably have got that during orientation. So we're going to try and make this as fun as possible.
Okay, but this is the first in a four-part series to help teach you about the law. So you will be ready to start taking cases in the fall.
It's exciting.
The first topic we're going to talk to you guys about is case prep and strategy, and there's a lot in there, so we're going to go step by step through it. So when you sign up for a trial by peers case, you are signing up for a 3-week obligation, and then as a peer counselor or peer advocate, you have certain duties. You have the duties and to keep your ethical rules and some duties of confidentiality and avoid conflict. So let's kind of go over the basic stuff. I want to start with your duty to avoid conflict. So trial by peers, as we all know from the orientation, is a educational program that is a diversionary program for young juvenile offenders who we will call subject minors. Okay, it's important to understand that the focus is on the subject minors and the community. So, if you, as a senior attorney, know a person from, like, say you go to school with them, you're in classes with them, your best friend got in a fight with them last week, or whatever it is, if you feel you have a conflict, you absolutely need to let the Tribe by Peers staff know right away. It doesn't mean anything bad. In fact, when you identify a possible conflict as an attorney, it means you're doing something good. Okay? So I want to start with that. I don't want anyone to think that identifying a conflict ever means something bad. It actually means that you are doing the right thing, that you are alerting everybody that there's a possibility of a conflict and you're avoiding it. That's good. Okay? Also in the Trial by Peers program is the duty of confidentiality. Us as attorneys have a duty of confidentiality in real life, and you guys have one in Trial by Peers. And what that means is anything that you learn through Trial by Peers or representing either the state or a subject minor means you can't tell anybody. It's a secret. Everything is remaining confidential. It's like you never knew it. You're not allowed to use anything that you've ever learned through your representation as a peer counselor or peer advocate for by trial by peers in any other way. Okay, you can't use it later in a trial by peers case. You can't use it later in your science class or anything. Okay, everything is considered confidential. Okay, you have a lot of ethics responsibilities as well, and I want to go through some of those because they go into case preparation and strategy because you have some duties. You have a duty to be a zealous advocate. I know you guys read the handouts, but I want to highlight some of the stuff that is really important. You have the duty to be a zealous advocate. That means that you are prepared. That's why there is a whole week on case preparation and strategy and how to go through these cases and what to do with them because it's that important, guys. So, make sure that you have a duty to meet your deadlines. You have a duty to tell the truth. You cannot lie to anybody, not your senior attorney, not your client, never promise anything, and certainly not the court or the jury. Okay. You also have the duty not to what we call proffer, which means I was going to say illicit, but that's another big word too. Okay, you can't have anyone else tell a lie to either the jury or the judge. If you know of anyone planning to tell something that's not true, you have to report that. You have to say that to the trial by peers staff because it's really important, that information. So another really big case preparation strategy, ethical duty that you need to know is you can never withhold information or evidence. So back in my day, but back a long time ago, there was this TV show called Perry Mason. And he was a very charismatic attorney. It was a legal drama, and he would have these what's now known as Perry Mason moments, where there would be a surprise right in the middle of trial, and it would change the whole thing. And it added lots of great TV drama, but it's completely unrealistic. Okay, so you'll hear me say it in the future. There's no Perry Mason moments in real life. Okay, and there's no Perry Mason moments in trial by peers. You're not withholding anything. In fact, if you have evidence either way, you need to bring that to both the trial by peers staff and to the other side so they know how to make the best determination of what their case should be. Okay, so you have the duty not to withhold anything. And you have the duty to, and this is going to come big when we talk about plea bargains later on in this session, you have the duty to recognize the subject matters rights. Okay, what are those big rights that you must, no matter what side you're on, honor and recognize? They are the right to plead guilty or not guilty. If you make a great deal with your super negotiation skills, it's still the subject matters decision whether or not to plead guilty or not guilty. Okay? It is the subject matter's right to either accept or reject any term of negotiations. If they think that you are not making the best deal for them and they don't want to do it, they don't have to. Okay? Any part of that. And whether that be your community service hours, your jury duties, whatever it is. Okay. The last one is whether or not to make a statement and or testify or not. So if you're doing a sentencing argument, they can make a statement or not. And if you're doing a trial, they can take the stand and testify or not. Okay? It's really important that both sides recognize those rights. Okay. And you are expected to anticipate, which is another big case preparation and strategy point. Anticipate the other side's arguments. Don't just be blindsided and let yourself get wrapped up in what you're arguing or what you want to do. Okay? You want to make sure that you are looking at everything, play devil's advocate, make sure that you see the other side as well. Okay. And lastly, you want to make sure that you know that you are expected to show respect, okay, to the subject matter, to their family, to the community partners that we deal with, to the judge and to the jury, and to the opposing counsel, okay? We treat each other with respect. It's super important, and it will only hurt you if you are not doing that. Okay, so now that I've given you some of the expectations and highlighted some of the most important things that you will need to remember, we need to go through case prep, okay? And the number one key to case prep is you're going to get a partner, okay? We all have partners, just like you see here. Mike and I are partners on this. It is important that you communicate with your partner. Absolutely, number one thing that you need to, as soon as you get the case, the first thing you do, communicate with your partner. You need to divide tasks, make sure you know what the other one's doing, and make sure that you know your case, because you're equally responsible, guys. You are equally responsible for your cases that you are assigned in trial by peers. Heaven forbid anything happen, but something could happen to your partner and you could be expected to do everything on your own, so you need to be prepared for that. Remember, number one key thing about getting a trial by peers case, equally responsible. Nobody wants to hear we can't go forward because that was Joe's part of it and I'm not ready. Nobody wants to hear that. Okay. So there's a schedule. You will get your cases 3 weeks in advance. So week 1, it's really important that you know what to do each week. So we're going to run through these things. I know they're in the materials as well, but we're going to point out the highlighted parts so that you know what's the most important. And the first thing that you do when you get your case is absolutely become familiar with everything. Read through everything. Make sure you know. If there are things that you don't know, make sure you write down some questions so that you know what you want to know. Identify whatever the charge is. whether you are prosecution or defense, you want to know what you're talking about. Do some research, get the exact language. Now you're ready for a strategy. And when you sit down, you need to decide what would be the strategy that would best benefit the subject minor. And that means a couple of things here in the Tri by Peers program.
The most important, we will have talked about this in orientation, but you're going to hear it a lot throughout this course, is restorative justice. When you're planning your case strategy, everything that you think of, everything that you plan, every piece of, if it's for a guilty case or if it's a trial case, whatever you touch, you need to have restorative justice, the restorative justice principle, as the bedrock of your thinking. What is restorative justice? As we've talked about previously with your first packet and your orientation, and as you'll hear throughout the course, restorative justice is essentially a method that we're going to be using to make sure that the subject minor involved in the case is we're going to try and prevent that subject minor from coming back into the system. Trial by Peers is a diversionary program. We want to make sure that when the subject minor leaves this program, that they don't ever come back to the juvenile system ever again, or heaven forbid, they come back in the adult system as criminals. So how do we look at that when we're looking at what to do? So let's first start with the definition. There are essentially what restorative justice does is a system of criminal justice which focuses on the rehabilitation of subject minors through reconciliation with the victims and the community at large. What does that mean? Like I said before, we want to make sure that these subject minors do not come back in the system. How do we do that? We kind of open their eyes to what happened in their situation. Sometimes that's going to be hard because you're going to have clients or subject minors in the program that they didn't do anything wrong, and that is what it is. You have to work with that. But a lot of the time, you're going to find that the people that become involved in trial by peers, they understand that some of the things they did might not be the best decision, and it's your job, even whether or not you're in the prosecution or the defense, to make sure that subject minor understands that their consequences do have actions. And we're not here to punish them.
Do you mean their actions have consequences?
Did I say that backwards?
Yeah.
Yes. So they're well, thank you, Felicia.
You're welcome.
Their actions have consequences. See, we're partners. So what you want to make sure is they understand and help them understand where do we go from here. Sometimes, hopefully in your cases, you'll be able to have, community partners. You maybe have the victim involved, and you can get them involved either through negotiations or even if you have to go to trial, there may be things that you can work out together. But the key is to make sure that subject minor does not come back into the system. So let's talk about restorative justice as a whole a little bit more. As we know, crime causes harm, and justice should be focused on repairing that harm. You can repair that harm with the victim. You can repair that harm with just the community at large. Sometimes you can repair it with someone who wasn't really involved in the case. Like a lot of the times, the parents get involved. So you have a subject minor who gets cited for something, use a fight or smoking marijuana, whatever it is. Now their mom's got to drive them down to the court. Now dad's got to take time off work to make sure that they get their community service hours. Now their teacher has to get involved. So just because you've got someone who's sitting in the chair at court, that doesn't mean they're the only person involved. There's a lot of people that touch that case, and what we're trying to do in trial by peers is make sure that everyone that gets involved in the case, there's some kind of reconciliation, there's some kind of repair that's done. And hopefully at the end of the day, that subject minor realizes, okay, what I did, maybe I could have made a better choice, and maybe I could have done something better in the future to not impact all these people's lives. And that's what the lifeblood of our program. So let's talk about the three concepts that restorative justice focuses on. First is repair. Like I said before, crime causes harm, and justice is repairing that harm. Encounter is the next principle for restorative justice, and that is the best way to determine how to repair that harm is have the parties decide together. Hopefully, most of your cases involve, at least even if it goes to trial, hopefully involves some form of the victim or other people involved in the case working with the subject matter to bridge that relationship back, and at the end kind of put things back together. That is the best case scenario. So even if you have a case that goes to trial, at the end of the day, you want that subject matter and the victim and the other people surrounding the case to all kind of get on at least see eye to eye. They may not agree on everything, but at least they understand the other side to where maybe that situation doesn't happen again. And the last principle would be transformation. So collaboration to repair the harm that can cause fundamental changes in people, relationships, or communities. And that, best way to explain that is, I think it's easy to always look at the victim and the subject matter. I think that transformation and the collaboration is really where you start looking at like the parents, someone involved not directly in the case, but other parts of the case. A perfect example is, let's just say someone goes and shoplifts at 7-Eleven. That person may think, it's a big corporation, 7-Eleven, they make a lot of money. But what they don't realize is that's one shop that's just owned by one person. And you didn't just hurt that person, but that person's got a family to feed. Anytime money gets stolen or something gets stolen, that's less money that they can use to, maybe they have a charity, maybe they're giving to trial by peers. So the harm goes a lot more, can go a lot longer than just that one person. So when you're thinking about your case strategy and you're thinking about case prep, be it the defense or the prosecution, you really want to look at how do we best serve this subject matter to prevent them from coming in again, and how do we repair this incident? How do we make good on everything with the victims, with the families, with other community partners? That is your goal as a trial by peers attorney. And that's a hard burden to ask. I mean, that's even more burden than Felicia and I have to deal with our cases. So you can't just think about your side. You're thinking of the entire community when you take these cases on, and that's a very big responsibility. If you ever have any kind of issues, if you have any issues with how to best serve that, who would be the best person you think the contact would be?
Your senior attorney.
That's
and
right.
You're going to hear us lecture that a lot through these 4 sessions on the summer course, is that when all else fails, contact your senior attorney. These are attorneys who are practicing in Clark County, who have graciously agreed to give up their free time to help you out. So the best thing that you can do is use that resource. It's absolutely beyond words how helpful it can be to talk to someone who's been there and can answer your questions. So absolutely reach out to your senior attorney. So I have another question for you, Mike.
Sure.
When I'm looking at my strategy for my case, does that mean I should just focus on like winning? Because isn't going to trial about winning?
It's actually not. It's not just about winning.
It isn't?
No. My opinion of winning a trial is making sure that, or winning a case is making sure that our subject matter at the end of the day, I know I've said this a couple of times, does not come back. Maybe they'll like the program so much they sign up.
Oh, okay.
So, and that's something you can offer them.
Right. So that's really important as well.
Yes. So, and it's funny you tapped me to talk about that. That's actually what I was wanting to bring up.
Mm-hmm.
Listen, we're attorneys for a reason. Felicia and I, you'll hear this a lot too, we love trial. A lot of the other attorneys in our office, sometimes they try and get out of it. Bring me trials. I love going trials. I cover a trial for her. She's trying to get me to cover more trials for her, but I have so many trials I can't. I know how fun trial is, and we're going to teach you all these awesome techniques and all these ways to have fun with witnesses, and you're going to be trial attorneys by the end of this. But you got to remember why you're here. You got to remember that you're here to make sure that these kids don't come back in the system. And more importantly, they don't come back as adults when they hit 18. That is the most important job you have in this system. And that means you need to think like the other side. And I'm going to give you 2 quick examples, and then I will let Felicia go and start teaching how to do case prep. And I'm probably going to hear these examples again, so listen to them. So number 1, you've got a bullying case. You got a kid who got into a fight, and you're the prosecution. You found out this kid's been bullied for years, and he finally decided, after getting bullied one last time, he was going to stand up for himself. Felicia, do you think we should give that guy the maximum sentence?
Well, what did he do?
Well, he stood up for himself and he finally told his bullier enough's enough and he started to fight. So do you think he deserves the max sentence or maybe a little less?
I don't think he deserves the maximum
Well,
sentence.
why don't you think then?
Because I feel like he was pushed into it.
Okay. So would you say that maybe context matters more than a fight?
Maybe, unless they did something really egregious, I think.
That's right. So that's a good example. You might want to see, why did this person commit the crime? Why did they get into this? If it's someone who just is a bully and likes to fight people, maybe if it's a prosecution, yeah, we'll get a higher sentence. But if it's just some kid who's just constantly been, attacked all of his life and he finally stood up for himself, you got to teach him you can't, violence isn't good and you shouldn't solve it, but you also don't need to throw the book at him. Same thing on the other side for the defense counsel. So let's just say, Felicia, I'm in trouble. I'm the subject matter. I'm the one who's the defendant for a change. I know you imagine that. Okay, I know it's hard.
No, it's hard.
And I have a witness that can kind of get me off on a loophole. What do you think of the defense attorney in trial by peers should do? Should they use that loophole?
No.
Why not? I
Because
can get out of the crime.
But it's more important to get you as the subject matter the maximum benefit than it is to get you off on some technicality.
So I know we act like we're having some fun with that, but those are two important scenarios, and that's how you need to think of your cases. The subject, that's why when I say the subject matter is the most important in the person in the room, that's what I mean. That means as a prosecutor, maybe you don't need to go full bore on them. Maybe you need to understand, especially if they've come in, I know what I did was wrong, I shouldn't do that. You need to tailor your arguments to that. Same thing on the other end. If you know you got a rock solid way of getting somebody off on a case, but you know deep down inside they shouldn't, then you need to make sure when you're talking to them, you're talking to the other side without breaking your ethical rules. You need to prep for that and steer the case in that direction. And that's where your senior attorneys are going to come into play and trial by peers representatives. So that is the essence of restorative justice right there.
Oh. So we take that all into consideration when we're deciding our strategy all the way in week 1 of our case preparation. This could mean that during our case preparation stages, we push this case away from a trial and maybe towards an ADR response to the situation. I know that you guys read that material already, but can you quickly go over okay, so in my case, my week 1 preparation, I'm going to decide, well, maybe this is something that it's a fight between a kid and the kid who's bullied him. Should we go to looking at a plea negotiation or a mediation for that instead? And what do we do if that's what we think?
Well, then that's something you need to go talk to your senior attorney about again, because that's another tool in your belt. I know you want to go to trial, but you might need to go to a negotiation and talk about maybe a plea agreement. You might need to talk about alternative methods to going to trial. Again, you're thinking as someone who's there for restorative justice, not just someone who wants to take cases to trial.
Okay, so if you're not ready for a mediation or a plea negotiation week 1, that's fine. The next thing you need to look at is mapping out your trial tasks. Treat every case like it's going to go to trial, and you will be the most prepared for no matter what you end up doing with the case. So you want to go ahead and contact your co-counsel, divide up those tasks. Remember, you are equally responsible for the cases that you sign up for, but you want to go ahead and divide up the tasks. You want to start identifying and interviewing your witnesses and reach out to your senior attorney after you have that information so that you can give them all the information that you've collected thus far in helping you come up with either the strategy, the route the case is going to take, or getting ready for trial. So you want to make sure that you have those things done in week 1. So week 2, you will either have met with your senior attorney or you're going to meet with your senior attorney first thing week 2. What does meet with your senior attorney mean? It does not mean you need to come down to our office and schedule a time. We're busy. Again, senior attorneys are attorneys who have a full-time job, full-time practice. This may mean a conference call. It may mean an email. I love email. Email me anything. I can respond to you when I can get to it and give you a full, well thought out response. Take the temperature of you will, as you do this more and more and more, you work with senior attorneys over and over again, and you'll get to know what they prefer. But as it starts out, call them, send them an email, let them know you're trying to reach out to them and you have some questions. Okay, make sure week 2 either starts with contact with your senior attorney or follow up with the contact you made at the end of week 1. You want to, if your senior attorney gave you any advice or anything to follow up on, you want to absolutely do that. And you want to follow up on any witnesses that you talked to the first time and had some questions about what they were going to say. Okay. You want to identify any potential witnesses or clear up any questions that your senior attorney raised or you raised with your senior attorney in terms of strategy and process. And that takes you to at the end of week 2, the last task is to contact your opposing counsel to discuss possible negotiations. So in week 1, you've already identified this is a case that's not quite ready or you're not quite ready to take it to a mediation or a plea negotiation. But by the end of week 2, you've contacted your senior attorney, you've looked at some stuff, you talked to some people, and you're thinking maybe I should be negotiating this. It's important that you know that you can reach out to opposing counsel, that you should be reaching out to opposing counsel, that in real life we do this all the time before any trials. That's where negotiations happen. So don't think that you can't reach out to the other side. And what you want to do is talk about what you can negotiate. Here in Trial by Peers, you have this really great, unique situation wherein you can have the subject minor plead guilty, negotiate that, and then argue for a sentence, or
You can negotiate different branches of the sentence.
and you can negotiate all of it in a plea agreement. So just make sure you're mindful of that. You have a lot of options, and anything that you can work out beforehand, before court night, do that. It actually shows that you're a great attorney when you're able to do that.
You can really negotiate pretty much up until, and this goes for real life too, pretty much until they start a trial or start the court. You can negotiate just about anything. And if you have any questions and if there's anything you can't negotiate, senior attorney.
Right. So say you haven't negotiated thus far, you're entering week 3. With your help of your senior attorney, you're going to want to finalize the theory of your case. Use that theory to draft your outline for opening statement, direct exam, cross exam, get closing argument, get your stuff done, get all that prep you did into some bullet points so that you can take that stuff to trial. And then here is really key. Co-counsel should be exchanging their outlines. Remember, you're equally responsible for your cases. You're going to want to exchange that and make sure that each person knows what the other one was working on so that you can pick up the ball at any point if you need to. You want to contact your witnesses with any final questions, and then obviously contact Trial by Peers staff with any logistical questions, and contact your senior attorney with any last minute help me advice type questions. Okay, those are all of your responsibilities. If you do not have time to do that, then you might want to rethink signing up, but it's one of the best things that you can do to help out your peers. So it's really important that you know, yes, you are responsible for all these things, but you have the power and capacity to change people's lives in this program, and you should absolutely be doing that as much as you can. Just like all of us who volunteer for that, it is remarkable to see kind of the effects of what your work has, and that's great because you don't always get that. You don't always get the warm and fuzzies when you get all the chemistry questions right, but when you get Trial by Peers right, it actually, you're doing some good. So kudos to everyone who's signing up. So let's talk about working with your co-counsels. Again, divide tasks equally. Make sure if you're doing the opening, he's doing the closing, that type of thing. Exchange outlines, communicate. Find out what works best for you guys. and do it. Be prepared for emergencies. Contact each other if you're feeling sick the night before and you're scared that you're not going to make it the next day. Call your co-counsel first, okay? You may contact your senior attorney together if it works in a conference call or something, or contact them separately, but just always remember you're going to communicate what the plan is and what each person's doing. So we talked a little bit about plea bargains earlier. And so Mike was going to tell you about what parts of the plea that you can actually negotiate beforehand.
Right. So you can definitely negotiate guilty or not guilty. That's something that was pretty much always available to you until you start trial. Even if you walk in and court's about to start and you think you're going to trial and your client, he's in front of the judge and they gets a little nervous, they can still negotiate and do a plea bargain essentially. So it's really almost never, the negotiations are almost never, a plea bargain window, is almost never closed. But even if they plead guilty, they may disagree on sentencing. So trial by peers has multiple prongs and requirements for sentencing. There's a community service hour requirement.
What's the requirement on that one?
It is a minimum of 8 hours or a maximum of 40 hours for each charge. So if you have 3 charges for a subject minor, each charge requires a minimum of 8 and a maximum of 40. So you technically could have someone have a minimum, 24 hours of community service up to law school, then math.
We did not go to math school.
Nope.
We went to law school.
So, but you remember each charge has it. Now you can negotiate just the community service part of the sentence. The next part of the sentence is jury duties. So each charge or citation requires a minimum of 1 jury duty, and I believe it's a maximum of 3.
Mm-hmm.
And you can negotiate that too. So, and we'll get into this more, but what do I mean by the prongs? You may agree, okay, this person needs 2 jury duties, but you may disagree on the community service hours. So you can go to the judge and say, Your Honor, we've agreed to the amount of jury duty sessions, but we disagree on the community service hours. So we're going to argue how many community service hours are required. The next element of a sentence that's required is a workshop. There are many youth workshops to choose from, and we usually tailor those to what the citation is. There's decision making, there's anger management, there's if it's a drug-related case, it's mandatory they take the drug series.
It's a 3-part series.
Correct. So it's 3 separate cases. I have seen one time Judge Sullivan, because of the underlying effects of the case, change that to something else. So the judge is allowed to make changes, so the judge rules all. But she judges a lot. But that usually the case will kind of dictate what your class is.
As if there's a peer pressure class too. So
That's
if
right.
the facts
That's a big one.
Reveal that this was a instance where someone got into trouble because of peer pressure.
Mm-hmm. I think decision making is another one too.
Yeah, decision making is
there's
another one.
There's a lot of classes. Mm-hmm. The last thing that's required, it's you can negotiate who it goes to, but you can't really negotiate your way out of it, is a letter of apology.
Why is that important?
That's because that goes towards our restorative justice model. So we want to make sure that that person apologizes to whomever is involved. And I guess the best example I have recently is I had a case that did go to a mediation, and one of the people, it was a fighting case, and one of the reason the fight started was one of the people said something about his fight partner's sister, and he said, I'd like to write in a letter of apology to your sister because I shouldn't have said what I said. So sometimes you can kind of talk to the subject minor about who that person best is, but it's usually someone, it's not necessarily the direct victim, it's somebody else. A lot of the times it's an apology letter to the parents. I took all this time out, you had to take time off work, you had to drive me down here, you had to sit in court for 3 hours. So you can kind of get creative with that. And realistically, you can include almost anything else in a sentence, and this is where your creativity comes in. You can think outside the box. Think what would best fit the situation and best fit the restorative justice model of making sure that the subject matter doesn't return. But as far as plea bargaining is concerned, you can negotiate each element of that separately. So let's just say you come to an agreement on the amount of community service hours, and you came to an agreement on the class to take, but you disagree on how many jury duties and who that apology letter should go to. You can go to the judge and say, we've agreed on these two things, and now we're going to argue about the other two. So
No, that's good. So that's good to know. And so there is a procedure laid out in your materials for if you manage to negotiate all parts of the plea, and you need to have that signed by not just the subject minor, but also by both sets of peer counsel and both sets of senior attorneys before you bring that into court. And like Mike said, that could be a week before or literally minutes before as you're walking into court. So it's always best to make sure that, since you guys know the cases better than anyone, since you did all this prep over the 3 weeks, that if you can negotiate any piece of this, then you should, and that's what you want to do.
So what happens if we negotiate everything? Does that mean I don't have to argue that night?
If you negotiate everything.
I can walk in and say, Your Honor, we got it all agreed to. I don't need to talk to you, right?
Wrong. You still have to present that to the judge, and the judge needs to approve it. And just like a sentencing recommendation from the jury needs to accept it and actually give that requirement to the subject minor. There is a very small, usually the judges, as we're sitting up there, respect the peer jury or the negotiations and will accept them unless we hear something that's really concerning and that we want to make some changes. But there is those far and few between times where the judge could refuse the negotiations, and at that time you just revert to argument so be prepared for argument on every aspect of your sentencing recommendations in the case of if the judge doesn't accept it, or the judge may ask you to justify it or explain why you came to this agreement, and you're going to want to explain that. You're going to want to explain what you were thinking, how this is fair to the community, and how this is fair to the subject minor, because again, you're looking at the benefit to the subject minor and the benefit to the community in our restorative justice model. So you want to make sure that you're prepared for that, because our big key here is prepare. So make sure that you have all of that done. So say the subject minor and the defense counsel agree on, yes, he absolutely did that, let's enter a guilty plea, but we don't agree at all on sentencing. So that opens up this option to you guys as trial by peers counselors, which is very unique to the trial by peers program, where you're going to have the subject minor enter a guilty plea and then do a sentencing argument. And then you'll hear all about sentencing, opening statements and closing arguments when we do trial prep in a few weeks. But for here, we're going to call this a sentencing argument. And there's 3 parts. There is the prosecution does the opening argument, where they will argue their sentencing recommendation. The defense then can argue their sentencing argument, and then the prosecution, because they bear the burden, will have a rebuttal. In the middle of that, right after the defense gives their argument, the subject minor has the right to make a statement. Remember what I said earlier, it is their choice to do that. You must respect their choice to do that. Typically, I know when I am functioning as a judge, I will ask the defense if they have anything else to present. They either say yes or no, or the defense can say, my client wants to make a statement. And I'm going to pause here on our procedure and make sure that if you are the defense counsel and your client wants to make a statement, you must review that statement with that client. And why is that important, Mike?
Because even though they're going to say what they want to say something, your job as their attorney is to protect their rights. So you want to make sure they're not going to say something that's going to hurt them anymore or damage their case or make them look worse or, God forbid, admit something else. You want to make sure that what they're saying falls in line with your case strategy and just make sure that they're protected because you're going to receive training that they're not. And even though you may explain things to them, you're just going to have more training than them. So your job is to protect them. So review the statement, make sure they're not going to say anything that's going to damage them or disparage them, any more than pleading guilty technically may. And make sure that what they're saying, and additionally, you almost want to make sure that they can say it, let's just say they say something and you're okay with what they're saying, but you may want to ask them to actually present it to you before the case, because if they're going to say it and they're laughing or they don't seem genuine, that may hurt them even more than if they just not said a word.
Right. And you want to make sure that whatever their statement is follows our restorative justice model as
Yes.
well. You don't want them to say, yes, I did it, but I'm not sorry because she deserved it. I mean, come on. You want to make sure that there's something that is in there that talks about not just what's best for the subject matter, what's best for the community and for the victim, and what will best benefit the restorative justice model. So
You also don't want them to lie.
right.
If they lie
Or deny.
right, that because if they plead guilty and then deny it, then
Right.
you have to almost start the whole process over. So
They lost all credibility.
right. So you got to make sure anything, even, and there may be more things than we mentioned here, but anything that can damage them, your job is to protect them as their attorney.
Right. Okay. So that's the subject matter statement. So let's go back to what the sentencing argument is. I'm going to go over some really quick basic components to it. There's some questions that each argument should answer. And these will seem familiar to you, the who, what, when, where, why questions. Who is obviously who did it, the subject matter, identify them. The when, make sure you recognize when this take place. Sometimes with the curfew violations, this is critical. Make sure that you include it. The where, did it happen on school grounds? Did it happen on the strip? Did it happen somewhere of significance? And what actually took place? The what is kind of obvious there. The why, this is super important to you in a persuasive arena. It's an argument, guys. You want to be persuasive. The why your sentencing recommendation is appropriate is very critical to your argument. You want to highlight facts of the case, circumstances of the case to justify whatever your sentencing recommendation is. This is important because if you just come out and explain what happened and say, he deserves 40 hours and 3 jury duties and 2 workshops and 6 letters of apology, and don't back it up with any why, you are not credible. You just sound like you're being mean. So make sure that you fully justify your recommendation. And on the other side, if you're defense counsel, you want to humanize your client. Make sure the subject matter comes across as a person to the jury and say, this is why I think what I'm arguing is appropriate. Okay. And if you're doing rebuttal or defense, you might want to throw in here why the other side's is not appropriate, but make sure you're not just taking stabs at other people and throwing shots. You want to make sure that it's all above board and it's grounded in facts. Why? The last question is how, and let me just do this one real quick.
That's fine.
How will the subject matter and the victim and or the community benefit from the sentence? And this is where our restorative justice model comes back in. Make sure everybody knows how it's going to be beneficial, educational, and make the world, as cheesy as it sounds, a better place. Okay, so make sure that that's persuasive as well, is showing how this is going to benefit everybody.
One thing I always tell, because usually we try to do feedback after arguments, and one thing I like to tell everyone is when they're going through each part of their sentence, so community service hours, jury duties, is I like to tell them more than just kind of say, well, they deserve this many hours and this many this and this because it's better for them. Take each element and explain it. I think 25 hours is a good community service hours requirement here because the crime they committed is significant enough that the more than the minimum should apply, and 25 hours is a good way to give back because they've taken 25 hours from the community if you add up those police officer hours and the parents' hours, and so justify each one. I think they deserve 2 jury duties because 2 jury duties will give them more an opportunity to review than just the one would, so they can see a wider variety of cases and see how their actions affect other people. So try and break that out within each element of the sentence and explain it. I see too many peer counselors, while their arguments are very good, they just kind of say, I want 8 hours, I want 1 jury duty, and I want this class, because that way they'll learn their lesson and they'll never do it again. So, well, how is that only gonna? How is you tell me what it's gonna do? How is it gonna get there? So take me there. So that's one thing I would like to bring up. Now you mentioned 3 elements to this closing, the sentence argument. You got the prosecution, the defense, and the rebuttal. The rebuttal, I can say whatever I want, right?
No,
I can't just no
rebuttal
argument.
is absolutely limited to what the other side brought up. Please do not drone on forever. And just like this video, we're gonna end it. No more. Don't say any more than you need to. Okay.
I like that. Good job.
You're welcome.
We'll see you guys on Saturday.
See you Saturday.